Sorry to not be there in person, but circumstances being as they are, I wanted to give this information to you some way, so we're putting this up as a video for you to watch. So you can do whatever you want while you're watching it, I guess. So far this semester, we've covered just about everything related to corporations. We talked about what corporations stem from in terms of their antecedent forms of partnership and agency law. We've talked about technical formation. We've talked about capitalization. We've talked about management of corporations and who are the managers, what are their responsibilities. We've talked about decision making and operation of corporations in terms of authority of different corporate actors. And we've even talked about fundamental business transactions involving corporations. Tonight we're going to talk about, quote, end-of-life issues, quote, in terms of corporations. I mentioned once in the semester that it's much easier to form a corporation than it is to dissolve one, and I think you'll probably get a flavor for that at the end of this lecture once you see the different procedures that are involved in winding up a corporation, dissolving a corporation. How does one actually terminate a corporation in an orderly manner? Are there any liabilities that are associated with dissolving a corporation? This last question is particularly interesting, given the fact that many companies are dissolved in the aftermath of failed businesses or in the context of disputes between the owners. What procedures are involved? What are the legal rules? We'll look at those statutes tonight as well. And why would anyone want to dissolve a corporation in the first place? Earlier in the semester, we had a brief preview of the process of dissolving a corporation or causing a corporation to cease to exist when we were talking about merger transactions, in which one corporation essentially disappears into the surviving corporation. That was a little bit of what we're going to talk about tonight in more detail, but that was our first example of the fact that entities that come into existence because of the statutory regimen and permission of the state also have to deal with the state when they disappear. You may have noticed that since now you guys are experts on Chapter 1701 of the Code, you might have noticed that the provisions dealing with end of life of a corporation appear appropriately toward the end of the chapter, specifically sections 1701.86 to 1701.883. I believe you all should have access to the statutes that I referenced in the syllabus. I am also sending them to you separately by email along with the link to this video so that you can have them at hand when I reference them during this lecture. It'll make much more sense if you have those statutes in front of you. I wasn't able to, well, I'll put it this way, it was beyond PowerPoint's capability to allow me to display those links within PowerPoint, so you'll have to look at them supplementary. The PowerPoints themselves, when they are uploaded to the website, will have live hyperlinks that you can use to access the statutes that we're talking about. If you've taken any time to look at some of the legislative comments that come at the end of the statute text, you'll see that there were major changes to the sections of the code related to dissolutions effective May 4, 2012. So much of what we're talking about tonight is relatively new law. I want to look at a few fact patterns that come up in practice fairly commonly, and these are governing dissolution and winding up of a corporation. The first one is, I call, incorporating was a bad idea. So here's the situation. you met with 4 individuals who asked you to set up a corporation for them to operate their apparel business. And you drafted and filed articles of incorporation which authorized the issuance of 1,200 common shares without par value, that is, without stated capital. And you actually issued shares to the shareholders by accepting subscriptions and accepting their money and issuing share certificates. Those individuals in turn elected themselves as the directors, and as directors they adopted a code of regulations and they appointed 2 of their number as the officers of the corporation. And the board convened its first meeting to discuss the company's business, at which time it became apparent that this was not a good idea. It was a mistake on everyone's part. They come to you and say, how do we get rid of this corporation that we just formed? This brings us to the basic voluntary dissolution statute, which is 1701.86. And the statute says that there are several things that have to happen. There has to be some kind of a resolution of dissolution stating the fact that the corporation, either its shareholders or directors, have formally met and voted to dissolve the corporation. The statute also says that if you look at subsection B, it gives some detail as to what that resolution of dissolution has to say. And if you look at section C, this is the section that impacts us particularly in this typo. It says, if an initial stated capital is not set forth in the articles, and that would be our case, then before the corporation begins business, the incorporators, or a majority of them, may adopt by a writing signed by each of them a resolution of dissolution. So in other words, no par stock, no stated capital, they haven't begun business, they can wind it up fairly simply, and this would be the subsection that you'd be referring to later in the certificate of dissolution, which we'll look at. Subsection D also talks about a number of situations in which the directors may adopt a resolution of dissolution. For instance, D3, when substantially all of the assets have been sold at a judicial sale or otherwise. So, for instance, let's say we engaged in an asset purchase transaction in which we sold all of our assets to a company. We have no more assets left. All the money has been dividended up to the shareholders, that proceeds of the sale. So this is just a shell company with no more money or anything. That's a situation where the directors, for example, may dissolve the corporation. And there are other examples there as well. Subsection E says the shareholders may adopt a resolution of dissolution by a 2/3 vote of the shareholders, generally. And that is one of these high vote requirements because this is an extraordinary measure. Once the resolution is passed, whether it's by the shareholders or by the directors, subsection F requires that there be a filing with the Secretary of State, a certificate of dissolution on a form prescribed by the Secretary of State. And as we know by now, we have a nifty form that the state has generated. In this case, it's Secretary of State Form 561. And we saw this briefly when we looked at mergers. It requires the company that's going out of existence to state its name, its charter number, where its office is located, and in this case, also the internet address for any domain that the company maintains. And this is a bit of a nod to modern technology, but it's important if you're trying to track down the company, for instance. It requires that you list the statutory agent. It requires that you cite the particular provision of 1701-86 under which you are dissolving. So that's why you have to know the statute that we just looked at in order to fill out the form. You're also required to acknowledge the fact that 1701.95 applies. What does that mean? 1701.95. If you take a look at it, you'll see that it's the statute that prohibits directors and shareholders from liquidating a corporation and then keeping the money without paying creditors. So you're required to acknowledge that in this form. The notice of dissolution also contains a reference to a claims procedure, which we're going to talk about in a little bit. The fact that we have to give specific notice to people who may have claims against the corporation that's dissolving. Finally, because there are a number of government entities that could be impacted by this, you are required to either obtain releases from those entities, or the more common procedure is to fill out an affidavit in lieu of getting releases. The affidavit is signed by your client, and it basically is saying, we notified these agencies that we are going out of business and dissolving, so that they could make any claims against us that they might have for unpaid taxes or fees. And these are important agencies. So for instance, the Ohio Bureau of Workers' Compensation is required to be notified. The Ohio Job and Family Services Department, otherwise welfare or unemployment, is obligated to be notified. The Ohio Department of Taxation is required to be notified. Obviously, these guys have first dibs on any money, so you have to let them know what's going on. And then, of course, there's some helpful instructions on how to complete the form. Okay, I want to move on, since we've covered 1701.86 generally, and we've even looked at some details of it, and we've looked at the mechanism for providing formal notification of that to the state and to other governmental agencies. All right, I want to look at another example. This is one that, again, is not particularly uncommon. So listen to this. So for the last 6 months, your client has been supplying sheet metal to Stampco. Stampco is a company that takes sheets of metal, stamps auto parts from them, and then sells them to General Motors. The reality of doing business with GM, of course, is that GM dictates terms of payment. And in this case, Stampco has paid your client for the sheet metal as and when possible, always blaming slow payment on the dictates of GM. When the accounts receivable owing to your client reach a critical level, your client begins placing calls to Stampco. And this continues for several weeks. Later, your client drives by Stampco's plant and sees that the place is padlocked, shuttered, lights out. Its phone has been disconnected, emails bounce back, undeliverable, and your client eventually learns through the trade, that Stampco has ceased operations, sold off its assets, and its owners are nowhere to be found. How could this happen? This is going to get us into a conversation of talking about 1701.87. 1701.87 is the Notice of Dissolution statute. If you pull this one up in the materials I sent, you'll see that prior to May 4, 2012, this was not uncommon for a corporation to dissolve without giving notice or not giving adequate notices to its creditors. Obviously not good for you if you're a creditor. If you look at the version of 1701.87 that was effective until May 4th of 2012, it's sum total of 6 lines, basically saying you'll publish notice in the newspaper for a couple weeks. You'll try to send a letter by regular mail to known creditors, period. This was obviously a recipe for disaster if you were a creditor. I'm amazed that it took until 2012 for the state to actually incorporate something that was more substantive. And that brings us to the new, as of May 4th, 2012, version of the statute. I want to talk about another scenario here. Again, let's go back to our first hypothetical where we had the four individuals who formed a business to design, manufacture, and sell apparel. Let's assume that they got through their initial cold feet and they decided they could work together. And in fact, they successfully ramped up their business by leasing a manufacturing facility. They bought some industrial grade sewing machines, some packaging equipment. They bought computers and office equipment. They even bought some computer software licenses for design packages. They bought company vehicles, trucks, and other delivery vehicles. And the business has been phenomenally successful for the last, let's say, 15 years. And folks all over the world are wearing clothes bearing their distinctive logo, and the owners have made enough money to retire. They've even sold the trademark rights in the logo to a third party. Now they've come to you to get your assistance, and the question is as basic as, what do we do now? They don't have any succession plan in place. They're not interested in transferring it to other folks who happen to have had a stake in the business as employees. And what steps do they take? What procedures govern the process? Some of this may seem like it's just purely business, but there is a legal component to it. And that's where we start to get into the provisions of 1701-88. 1701-88 is the winding up provision. So if you have that in front of you, it's called Winding Up or Obtaining a Reinstatement, Powers and Duties of Directors. The statute says that when a corporation is voluntarily dissolved, that would be our 1701.86 scenario, or when its articles have been canceled, say for failure to pay corporate activity tax. The corporation continues to function for a period of up to 5 years. Now, this may sound strange. You think that we've dissolved the corporation, All that means is that the state has terminated recognition of that entity as a functioning business unit, but it doesn't prohibit it from continuing to do what it has to do to actually close up its operations. We'll talk in a minute about what some of those might be. So the statute contemplates about 5 years of activity beyond dissolution. And what are the types of things that may go on? Well, if we look down at 1701.88d, it talks about the directors proceeding as speedily as possible or practicable to complete the winding up of the affairs of the corporation. And for purposes of the statute, that means that the directors can fill vacancies on the board of directors, they can elect officers, they can appoint liquidators or people to sell off assets, they can continue to perform contracts that haven't run their course, they can even make new contracts, they can borrow money, they can mortgage the property of the company, they can make conveyances, they can even enter into leases, they can compromise or settle lawsuits, etc., etc. This is, when you think about it, some businesses are extremely complicated and have a lot of moving parts, and it's not as simple as just selling off one building and then going home. There are oftentimes contracts that have to be honored. There are employees with whom they may have contracts. There may be union obligations. There may be open orders that have to be fulfilled that have been in place for a while and extend out into the future, long-term supply contracts. So the statute recognizes the fact that winding down can be complicated and it doesn't necessarily happen instantly, and so there's a limited authority to continue to operate during the winding down period. But that being said, the statute also goes on to say that if you look at 1701.88b, voluntary dissolution or cancellation of the articles doesn't eliminate any remedy available to or against the corporation or its directors, officers, or shareholders for any right or claim existing or liability incurred prior to dissolution if the corporation if the corporation brings a time limit within the statute for that particular cause of action, and for any other person if they bring the cause of action within 5 years. So there is a 5-year survival period on claims for things that happened prior to dissolution. Clients are sometimes surprised to hear this. A lot of clients have the mindset that I've dissolved the corporation, I have no more responsibility. What are you talking about? I can still be sued. Well, that's where you have to educate your client and help them to understand that you may be dissolving this and winding it up because you're moving on to another business or you're retiring, but there's still liability associated with what happened before the corporation was dissolved. And that also relates to derivative actions brought in the name of the corporation against officers and directors, as well as third parties who may have claims against the corporation. So important point. So another provision I want to focus on is subdivision E. This contemplates a section we're going to look at in a minute that says, if necessary, the directors may engage the court in the process of helping supervise this winding up. Why? Because, well, As you might imagine, corporations sometimes dissolve and wind up in a rather messy manner and in messy circumstances, and oftentimes with rancor among owners of the entity, such that they need to have the court step in and oversee what's going on with the dissolution of the business. So the takeaway from this is that dissolution does not mean cessation of all activity, and dissolution also doesn't mean termination of liability. That's a very basic statement of the fairly complicated statute, but that's our takeaway. Now, that being said, let's take a look at an actual case we have that deals with this very situation, and that would be the Columbia Title versus Columbia Agency case. It was one of the supplemental cases that we've been looking at. So what was going on in Columbia Title versus Columbia Agency? As you may or may not know, title insurance is insurance that ensures a clean chain of title so that whoever buys the property doesn't later experience someone claiming that they have an interest in the property. Columbia Real Estate Title Insurance Company was the actual insurance company that insured that risk. Columbia Title Agency was an company that sold that insurance to end users, typically people involved in real estate transactions. In this case, the agency, I'll just refer to it as agency. Agency's articles were canceled in 1977 for failure to pay taxes. I believe we had franchise tax back then as opposed to the commercial activity tax. And so they didn't pay their franchise tax. The articles were canceled. That's a classic reason to have the articles canceled. Keller buys into the corporation in 1978. Apparently he hadn't done his due diligence and didn't realize that the charter had already been canceled. The insurance company, I'll call them insurance, and agency entered into a contract in 1979 whereby the agency would sell these policies of insurance, would receive applications, would issue title binders, would pay the premiums to the insurer, and at a certain point in time the agency failed to pay premiums, and it got sued along with its owner, one of its owners, Kelly, on the grounds that he had defrauded the insurance company as well as some of the banks by using premium funds for his personal use. The insurance company sued everybody. Now, procedurally what happened was the court entered judgment against all the defendants, and they awarded punitive damages and attorney's fees against Kelly, but not against the other defendants. Kelly and the Columbia Title of the agency did not appeal, and so the appeal is by Keller, and this is presumably because Keller was the last man standing and had some resources of some kind, that he had something at stake in defending this. Since Kelly had apparently was either judgment proof or has made some sort of a deal, the insurance company was trying to find someone liable of the remaining shareholders, that is Keller and Kelly and Keller. So the argument that they tried to make, which I thought was rather creative under 1788, was that since the charter of the corporation had been canceled, that rendered the individuals simply a de facto multi-owner entity, which, as we know, is a partnership. And as we know from earlier in the semester, partners are individually liable for the obligations incurred by their co-partners, and so insurance company was making the argument that Keller was individually liable for the liabilities of his co-partner Kelly. Of course, the court said, "Good, nice try." Even though there is a provision that may support that argument, at least under common law, and maybe even under 1775.05a, which remember says you're a partnership whether you know it or not. We had a specific partnership statute under 1775.05b that says you're not a partnership if you formed another type of entity under another type of provision of law, whether or not it's canceled or not. In this case, the court said you had taken advantage of Ohio law to form a corporation. It doesn't mean that you're a partnership. You're a corporation. You just happen to be a corporation whose charter was canceled because you hadn't paid your franchise taxes. And the court goes on to cite our statute 1701.88a, which says, as we know, a corporation continues to exist even after cancellation for purposes of winding up. And as we saw also, even 1701.86, specifically 86d4, contemplates continued corporate existence after articles are canceled. Now, again, this is continued corporate existence for a specific purpose of winding down the entity, and presumably that's what was going on in this case. We don't have a whole lot of facts on it, but presumably there was enough at the trial court record for the court to feel that they fell within the provision of 1701.88 that allows some continued activity in the service of winding down the entity. So this is, I guess we have this as it's an example of another example of how the statute plays out in reality. Still liability, and again, this is one of those cautionary tales that you tell your clients about when they're considering dissolving as a means of getting out from under problems. Your job is to tell them that you're not necessarily going to get out from under all your problems. I want to talk a little bit about 1701.89. I don't think I have a slide on this one, but I referenced it a few minutes ago when I talked about judicial supervision of winding up a corporation. This is, as I said, a mechanism that sometimes you call upon if the winding up or dissolving gets messy or becomes contentious. And as these things typically do get messy and contentious, it's not terribly uncommon for one of the parties to enlist the involvement of the court to be the grown-up in the room and to establish some order, because otherwise the process of winding up, there's no template. It's simply the company, it's simply the directors doing what they have to do to dispose of the company's obligations, and so there's lots of room for dispute, and there are lots of room for gaps in the process. So the way this works is, upon the complaint of the corporation, a majority of the directors or a creditor or claimant, and upon such notice to all the directors and such other persons interested in the court that the court considers proper, at any time the court can order and adjudge the following, and it references again this claims process that we're going to talk about, and the liquidation and winding up of the corporation. Now, notice this doesn't say except as provided in the Articles of Incorporation or except as provided in the Code of Regulation. It says, upon the complaint of the corporation, a majority of the directors or a creditor or claimant, and upon notice, the court may order and adjudge these matters. Arguably, if you have a provision in your articles or regulations that purports to void this provision, your articles or regulations would be overridden by provisions of 1701.89. All right. I think that's all I wanted to say about that. Oh, let's see. I guess the only other thing I want to talk about under 1701(89) is among the things that the court will look at is it will look at claims that may have been submitted to the corporation that's dissolving, or we'll talk about that in a minute. It may talk about the propriety of settling any lawsuits or claims that are pending against the corporation. The court may talk about the rights of shareholders, and again, this is important because, remember, in the dissolution and winding up procedure, the goal is to generate cash which will be used to pay the claims and the debts of the corporation, and then ultimately to distribute those as dividends to the shareholders. And we've talked about before, sometimes this is the only liquidity event of a closely held corporation, is upon its sale or its dissolution or winding up. So the court will supervise that. The court will oversee reports given by the directors during the process to make sure that they're accounting for everything. The court can fill vacancies in the number of directors when the directors are for some reason unable to do that. The court may appoint a receiver, and we've talked about what that is. That's a special purpose third party who's put in place to run a business. The court may oversee the allowance and payment of compensation to the directors, again, assuming that they're arguing about this. And the court can also order the transfer of real estate. Essentially, the court steps in and almost acts like a receiver itself when you successfully enact or call upon 1701(89) to play a part in one of these processes. All right, I want to talk a little bit now about all of the provisions we've covered so far existed in some form prior to 2012. The following three sections of what I'll call the dissolution and winding up series of statutes are the relatively new statutes I talked about earlier that became effective for the first time on May 4th of 2012. And I wanted to take them one at a time. Again, these are brand new mechanisms that didn't exist before. The first one is 1701.881, Notice of Rejection of Claim. So we looked at the earlier provision that it talked about giving notice under 1701(87 that required that we send out specific type of notice in a specific manner to creditors of the corporation, telling them that we are dissolving, going out of business, and giving them an opportunity to put in a claim. And we indicated that there was a particular place those had to be sent. We had specific content that was detailed. This section talks about what happens if you do receive a claim. And and periodically, because there is better information out there, you can read about it on the Secretary of State website. You may have received a certified letter from the company. Hopefully these will trigger claimants making claims against the corporation. This is their last chance. (1701.881) states that the claimant must make a claim within 90 days of receiving the notice from the corporation. Statute goes on to say that the notice, if the claim is rejected by the corporation, the claimant has 30 days to actually commence an action to enforce the claim. So this regimen doesn't necessarily say that the corporation can automatically reject a claim and it goes away. It simply says that if it's rejected, the claimant has 30 days to enact a lawsuit to enforce the claim, and that presumably would be under 1701(86) that we looked at before. The next section that I want to look at in this series is 1701.882. This is the provision that actually talks about actions on claims upon dissolution. So it says that a dissolved corporation shall do all of the following: pay the claims made and not rejected under 1701-881 that we just looked at, or make a payment required by the court if the court has gotten involved under 1701-89 and determined that a particular claimant is entitled to payment for his debt. There's also a mechanism for the company to post security for the claims. I'm not going to get into talking about that. I'm not going to hold you to that. That gets more technical than we need to. But basically, the corporation has to pay the claims, or pay the claims that are ordered by the court. But the question is, what if the corporation doesn't have the money? And if we look at 1701.882, it says the corporation shall pay in full any claims and liabilities, or provide for those payments in full by insurance or otherwise, if the corporation has sufficient assets. And it goes on to say that if the corporation does not have sufficient assets, a corporation shall pay claims and liabilities or provide for those payments by insurance or otherwise in order of their priority. In other words, first of all, the corporation has to have sufficient assets, and even if it doesn't have sufficient assets to pay all claims in full, it has to pay them partially in order of priority. And it goes on to say that among claims of equal priority, the corporation shall apportion those payments to the extent of funds legally available for the payment of those claims. Any remaining assets get distributed to the shareholders, of course, because that's what's left after payment of debts is the dividends that get paid out to the shareholders. Note, it doesn't say that there's a personal obligation to pay out claims on the part of the directors. They must be paid out if the corporation has sufficient assets. And then finally, the statute says that in the absence of fraud, the judgment of the directors of the dissolved corporation as to the provision the corporation made for payment of all claims of this section shall be conclusive. In other words, if the corporation's directors have determined in good faith, in the absence of fraud, that they simply don't have enough money, or that certain claims are bogus and shouldn't be paid, that's going to be given the certain presumption that we've been talking about all semester, the presumption under the business judgment rule. So again, even in this regimen, in the absence of fraud, the business judgment is going to be determinative in those decisions of how to pay out on these claims that have been properly submitted with the right amount of time, but that are in fact disputed. The last provision I want to talk about in this series is 1701-883, and that's the provision that talks about liability of shareholders of dissolved corporations. This is the one that you need to make sure your clients understand exists. It says in subsection A, the dissolution of a corporation shall not affect the limited liability of a shareholder with respect to transactions occurring or acts or omissions done or omitted in the name of or by the corporation. That's good. The fact that they've dissolved doesn't mean you don't still have limited liability. It goes on to say that a shareholder who receives a distribution of assets from a dissolved corporation shall not be liable for any claim against the corporation in an amount in excess of the amount of the shareholder's pro rata share of the claim, or the amount distributed to the shareholder, whichever is less. In other words, assuming that the corporation has paid its debts appropriately, but nonetheless there is found to be a claim that has somehow survived this regimen, no shareholder, no director, or no shareholder is liable beyond what they received from the corporation. In other words, directors are not, or shareholders are not jointly and severally liable for all of the debts that may face the corporation, only for the amount of pro rata share that they received in distribution. And then finally, the 1701-883 references the essentially the 5-year statute of limitations on claims made against a corporation which has properly notified its creditors of the fact that it's going out of business. Summary: we have a very controlled, very circumscribed process, a specific process for both notifying creditors of dissolution, allowing creditors to submit claims, providing for the acceptance or rejection of those claims, litigating those claims, perhaps involving the judiciary in those claims, in that claims process. And none of this really existed in this sort of fashion before 2012. If any of you have had bankruptcy, this is very similar to the regimen that's existed in bankruptcy for 30 years. So this is almost like a mini bankruptcy that's available for certain companies. Bankruptcy, of course, is a federal procedure. This is purely a state procedure. Why might somebody want to go this route instead of going through federal bankruptcy? There are a number of reasons. It's probably cheaper. It's certainly faster than bankruptcy. It can certainly be customized. As you can see, the statute, even though it has structure, there's lots of ability for the company to design the timing, control the timing, and design the format of some of these communications. And it doesn't appear in the docket as a federal bankruptcy filed against any company or any shareholder. So that's why these are sometimes attractive to companies to use instead of federal bankruptcy. All right, I want to talk about another fact pattern. I call this one a tale of two doctors. So here's the example, and I may have mentioned it once already during the semester. Two doctors decided to form a corporation for practicing medicine, and this is actually a special form of corporation governed by Chapter 1785 of the Code. It's known as a professional association. It can only be formed by certain types of professionals, lawyers, doctors. At the time they formed the entity, one of the doctor's accountants filed some papers in Columbus, but that was it. They didn't create any corporate records. None of the documents that are recited in the minutes of the incorporator that we looked at the beginning of the semester, which is really the roadmap of how to correctly set up a corporation, that wasn't done. The accountant filed some articles and figured he'd incorporated them, and on a certain level he had. Both docs were equal shareholders, and they were both directors. They weren't sure if they were officers. There really weren't any corporate records. And as busy as they are, they didn't have any kind of formal agreement. There was no shareholder agreement of any kind. And things went well for the first few years. They pretty much divided everything, quote, 50-50, quote. But at some point, for some reason, the docs had a falling out. One of the doctors was not working as much as the other one. And since they had operated in this 50-50 world, it became apparent after a while to the doc who worked more that this just simply wasn't fair. It would have helped if they had a shareholder agreement that talked about what happens in these cases, but they didn't. And of course, the accountant who did such a wonderful job setting them up as a corporation was the same accountant who was making sure that each doc got his, quote, 50%, quote. And by the way, this was the accountant who was brought to the party by the doctor, who was a bit of a slacker. As you might guess, the slacker doctor had little incentive to see the situation change. He's a 50% shareholder. The presumption that he's entitled to 50% of profits in the absence of any kind of an agreement, and he certainly was getting his 50% of the profits. When the topic was brought up by the other doctor, he got nowhere. There was no agreement on anything, even though they both continued to practice medicine under the same roof in the same clinic. As you might guess, one of the doctors felt he needed to do something, and this is where we come into a provision that's kind of the nuclear option when it comes to deadlock. And we referenced this earlier in the semester when we talked about deadlock in close corporations. I'm talking about 1701.91, the judicial dissolution statute. This is similar to what we talked about a few minutes ago when we were talking about 1701.89. That was getting the court involved in supervising the winding up of a corporation, where you've already dissolved. You're having problems going through a lot of these decisions that have to take place in the process of actually dismantling and selling a corporation. This provision, on the other hand, is we can't even agree on dissolving because we have deadlock. And in this case, we have a statute that we saw before, and it says a corporation may be dissolved judicially and its affairs wound up. And I'll focus on the most common ones. Number 2, by an order of the Court of Common Pleas brought by holders of shares entitled to dissolve the corporation voluntarily when it is established that any of the following are true. Its articles have expired or have been canceled, the corporation is insolvent, or unable to operate with sufficient assets, the objects of the corporation have wholly failed or are entirely abandoned, or that their accomplishment is impracticable. Second major trigger, by order of Court of the Common Pleas, by the holders of shares entitling to exercise 2/3 of the voting power of the corporation on such proposal when it's established that it is beneficial to the shareholders to be judicially dissolved. Now, in the situation I posited, neither of those could apply because no one had a majority. So, and no one could unilaterally dissolve the corporation as a shareholder. So neither of those would work. So we look at the fourth trigger. By an order of the court in an action brought by 1/2 of the directors when there is an even number of directors. That's what we have here. That was our trigger. Or by the holders of shares entitling them to exercise at least 2/3 of the voting power when it is established that the corporation has an even number of directors who are deadlocked and the shareholders are unable to break the deadlock. And it goes on to provide some other circumstances for triggering this event when you have a shareholder that owns a majority but they still can't agree with the other ones on replacement directors. So in this scenario I posited it's a situation where we have 1/2 of the directors can bring the action when there's an even number of directors, and that it's clear that the corporation is deadlocked in the management of the corporate affairs, and the shareholders are unable to break the deadlock. So that's what was going on here. And the way this works is there is an actual complaint that gets filed by the complaining director in this case, setting forth the facts that support the argument, first of all, that support calling upon the statute, and that explain the fact that we're not able to get anything done. We're not able to function. The purposes of the corporation have been stalled because of this. The court sets up a hearing under subsection D, and the parties are allowed to give testimony, of course. The court may order something called a special master, which is a individual third party brought in, may it be an accountant, may it be a receiver type, who gets down into the weeds to determine whether in fact there is a deadlock that justifies calling upon the statute to have the court step in and judicially dissolve the corporation. And this is important because if the court ends up going all the way to the end and ordering dissolution, the court typically provides a roadmap as to exactly what's to be done, who's to get what, and the manner it's to take place. And this is all very involved, and it's definitely outside of the area of expertise of most judges. So they typically bring in a special master or a commissioner to go through this process and help the company actually get wound up. So as I said, that's kind of the nuclear option. If
can't even decide whether to dissolve. This is your last resort. And of course, as you can gather, it's expensive in terms of lawyer time. It's expensive in terms of time in court, and like most cases, civil cases, it will probably settle somewhere along the way. But this is how you go in with it until you get to that settlement point. We have the Sapienza versus Material Engineering case to give us an example of how one of these cases might actually play out in the real world. This is a 2011 case from Delaware County, down south of us. This is the case where we had, again, 50-50 shareholders who were involved in, looks like it was an engineering business. And one of the individuals was from out of town, and the other one was local. And the allegation was that the appellee was receiving information and was diverting it from the company that he was a shareholder of to another company in which he had an ownership interest. And aside from the allegations of diverting corporate information, there was also an argument about efforts to sell the company. As a result, there was a complaint filed alleging breach of fiduciary duty and misappropriation of corporate opportunities. One of the 50% owners was fired from his job, and the appellant counterclaimed seeking dissolution. The record shows that the shareholders had held an annual meeting where there was basically inability to agree on anything. They couldn't agree on anything at all, and they fought this instant action. Also included an appointment of a receiver, essentially almost like a 1701.89 judicial supervision of winding up. The court gives us a nice recitation of the facts, showing evidence in favor of deadlock, and the court really looks at this as more than anything else an evidentiary hearing regarding the sufficiency of evidence in support of the allegations of irreparable deadlock. Obviously, the one owner claimed that the organization was still viable and therefore it shouldn't be dissolved. But the majority opinion goes through and points out the fact that at the various meetings they'd had, the appellee had refused to participate in meetings. 3 other special meetings were called by the appellant, and the appellee failed to participate, resulting in a lack of quorum. And at the end of the day, the court has no problem finding that there's complete lack of deadlock in the case. And if we look at the statute, and the court cites 1701.91 A4, let's just take a quick look at that again. A4 points out the fact that the last sentence says, under these circumstances, dissolution of the corporation shall not be denied on the ground that the corporation is solvent, or on the ground that the business of the corporation has been or could be conducted at a profit. In other words, the argument that, well, you can't liquidate the company, it's still viable, it's still profitable, under our statute, that wouldn't be grounds by itself to grant dissolution. Now, we did have a dissent in this case, and the dissent seemed to hang his hat on the argument that the court has discretion, and that somehow the court in this case should have ignored that sentence I just read and prevented the dissolution from going forward. The court says that, and the dissent said that the statute doesn't require a finding by the court of deadlock. Rather, the standard of review should have simply been abuse of trial court's discretion. And he went on to say that this deadlock only occurred after the one owner sued the other for the alleged diversion of corporate opportunities. That might be a good point, but that didn't win the day. In this case, the majority relied on the provisions saying that even if you're profitable, with this type of an evidentiary record of deadlock, we're going to take advantage of the general principle that we don't want companies stuck in this sort of situation where no one can do any business. Remember, it doesn't necessarily just impact the two people. It might have impacted employees of the business as well, and perhaps suppliers of the business.
That's all I have on this topic. I hope everybody has a happy Thanksgiving, and please email me to indicate that you viewed this presentation. Thanks.